Welcome. I'm Vicki Kennedy, and on behalf of the Edward M. Kennedy Institute for the United States Senate, I am very pleased to welcome all of you to this very special edition of our Getting to the Point series. The Kennedy Institute is a nonprofit, nonpartisan place envisioned and planned by my late husband, Senator Edward Kennedy. It's a place where visitors come, now virtually as well as in person, to experience democracy through hands-on learning about the United States Senate, and then use that knowledge as a touchstone to understand the branches of our government. It's also a place where we encourage participatory democracy. In fact, we just started a nonpartisan effort called Just Vote, and I encourage you to go to our new website called justvote.org. But most important, I encourage you on November 3rd to just vote. It is the most important thing we can do as citizens. This is a place where we work to invigorate civil discourse and inspire the next generation of leaders. And I can think of no program and no speaker who meets every one of the goals that my husband had for this place more than today's special guest, Justice Stephen Breyer. Without question, Justice Breyer is a man for our time and a man for all times. Here in Boston, we're proud to claim him as one of our own. A graduate of Stanford, Oxford, and Harvard Law, he went on to clerk for Supreme Court Justice Arthur Goldberg. He served for many years as a professor at Harvard Law School and taught at the Kennedy School of Government. He was a lawyer in the Antitrust Division of the Justice Department and was an assistant special counsel in the Watergate proceedings. He was chief counsel of the Senate Judiciary Committee and thus achieved something that is very special around this place. He is a Kennedy staff alumnus. Teddy told me that more than anyone he ever knew, Steve Breyer had the ability to explain the most complex issues in the most understandable ways. And I do think that's one of the keys to his enormous powers of persuasion. From the First Circuit Court of Appeals to the United States Supreme Court, Justice Breyer has made history and been part of the most momentous issues of our time. We are faced with momentous issues again, and I think it fair to say, without exaggeration, that we are in unprecedented times. We are still grieving the death of Justice Ruth Bader Ginsburg, and we offer our deepest sympathy to all her family and friends and to all the members of the court. But as Justice Ginsburg understood would happen, her loss created a vacancy, and now there is a pitched battle for a nomination for a new justice in the midst of a hotly contested presidential election and for an election for control of the United States Senate. Yes, these are indeed momentous times. There is a reason that today's speaker has attracted the single largest audience ever signed up for one of our programs. In the middle of the day, on a Thursday, more than 2,000 people are eager to hear what the justice has to say, to the extent he is able. I too can't wait. To facilitate the conversation this morning, we are so delighted to welcome Ari Melber, an outstanding lawyer in his own right, the host of MSNBC's The Beat with Ari Melber. Ari received an Emmy Award for his reporting on the Supreme Court. So we know we'll have a lively, informative discussion this morning. I thank you all for logging on. I know you're as eager as I am to get started, so I'm thrilled to turn the program over right now to Ari. Thank you.
Victoria Kennedy, thank you so much. Thanks to everyone for being here. It is a great honor. And as we say, we will get right to it. I wanted to begin by welcoming Justice Breyer. We'll get to many things, but first wanted to just ask if you had any reflections you wanted to share about the passing of your colleague, Supreme Court Justice Ruth Bader Ginsburg. And taking a look at, I think that we have Justice Breyer, who I spoke to moments ago, so I know that he's here for us, but I think he has stepped in or out of the Zoom. So what we'll do then is I'll speak for a few minutes, a little bit about as well what we're thinking about today, with so much on the table for, of course, the country. Voting's already begun. The Supreme Court, which currently, as mentioned, with Justice Ginsburg passing, is a 4-4 court. So let me speak to that for a few minutes. They'll let me know as soon as Justice Breyer's back. As I mentioned, we saw him ourselves, you saw him, and I know that he's excited to be with us. A few points on the court, which I think are striking, is we're in a time where the court is now 8 justices instead of 9, but its work continues. Indeed, there are a slew of cases that come up across the country, and as always under our system, there are appeals and requests that are made by litigants for the court, the Supreme Court, to take things on an expedited or emergency basis. Just recently, there was a request that the court denied through Justice Breyer, for example, to hear a case regarding whether or not to allow a new form of voting in a particular state, where you would do ranked choice voting as opposed to more traditional first past the poll voting. And the Supreme Court declined to hear that case in that example. But it's a reminder of something that we've heard from people who are, of course, court watchers, as well as people who are keeping track of all these elections, state, local, federal, which is that a court that's one justice down could still be vital, both in the rulings or decisions not to rule in the run-up to the election, as well as whether or not there are any big cases that could resolve or address any potential contested election. So it's a very interesting time, I think, in that respect. There's been also a lot of talk, which I want to ask Justice Breyer about, regarding honoring precedent and when and how the court does depart from that. And he sounded an alarm in a recent case regarding the relatively arcane issue of when and how states can or can't be sued, but prompting a larger discussion that several justices signed on to about what is the higher bar for overturning precedent. That's something that we hear about in Supreme Court confirmation proceedings. It's something that I think lawyers and non-lawyers alike discuss, because it's that basic question of, okay, we have rules, we have precedents, and yet sometimes they change. How and why? So that's something I think we definitely want to discuss. And then more broadly, of interest, I think generally to non-lawyers as well, I think we definitely will touch on, and I want to ask Justice Breyer about, of course, his link to the Kennedys, having been counsel to Senator Kennedy, as we're obviously here at the Kennedy Institute, and thinking about that. This has been a time where the recent era has had, I think, many national conversations among citizens, in law, in the press, about the role of the different branches of government. What do co-equal branches mean? What does it mean that we have these certain expectations? I believe we have Justice Breyer back in. I was just speaking to folks briefly. Thank you again for doing this, sir.
It's the wonders of technology. That was a very nice introduction, but obviously I'm so modest that this machine decided to break down. Nice to be here.
Exactly. Yes, it's something technological and constitutional in receiving so many accolades. I was just speaking a little bit about some of the things we would get to. I know you were in and out, so anything there I'll bring back up with you. But I did want to just make sure that we reflected briefly and gave you a chance to speak for anything you did want to share about the passing of someone who was a dear colleague to every member of the court, Justice Ruth Bader Ginsburg.
Yeah. Well, she was a good friend. Oddly enough, I was attending via Zoom a Jewish New Year service, the Rosh Hashanah service, in the evening with my daughter and grandchildren. And at the end of the service, there is the prayer of mourning, the prayer for the dead, the Kaddish. And we're seeing people were standing and saying it, and said it was an emergency. I got it and told me Ruth had died. My goodness. And the thoughts that went through my mind in focusing on her, you know, a woman of valor, a rock of righteousness, and my good friend. And she was very hardworking. She was, I mean, when she decided that's the way it goes, that's really good. And I'm back again. Hello.
I can hear the justice, but I'm having a little trouble. Oh,
Yes.
you better now. You're
I
moving.
suppose I take it downstairs. If I take it downstairs, you know, it might work better.
No, I will say this, as we all work through 2020 together, it's already better this moment than it was 2 moments ago. So we'll give you a moment to reset, and we appreciate you going.
No, here it's on. Okay. So I was going to say she was a really nice person. I mean, just a few weeks ago, my son, we had a new grandchild, and she sent him a present, and the present was a T-shirt which said, future law clerk for RBG. Okay. And then she knew this, she'd looked into it, you know, and she said that she wrote a little note saying, it's probably too big for you, to my newborn grandson, but why don't you give it to your brother, Ryan, who's his half brother. And so she knew about Ryan. And I go into my office for the service for her, and there on my desk is a birthday card from her, which she'd sent a few weeks before. And it says, to my younger colleague. Right, underlined, she said younger. And you know, she was, if you're sitting next to her at dinner, she might not say very much. And Joanna said to me, you know, when she has nothing to say, she doesn't say anything. She thinks. And then when she's speaking, she's thinking. And I felt there was a little comparison there that she was making, because she told me, you know, Stephen, not every silence needs to be filled. Good point. But Ruth, she understood that. And she was the kind of person, the more you know her, the more you like her. I mean, my goodness, I'll miss her. And not, I mean, you know, she loved opera. Boston, I called her about 3 weeks ago and said, my God, for some reason we were talking, there's some opera that takes place in Boston. Do you have any idea what? Yes, she said, that's a masked ball. It's Verdi. Everybody knows that. Yeah, well, I didn't know that, but nonetheless. Oh, dear.
I really appreciate that. And again, I want to thank you for working with us through the technology. I'll just reiterate now, we can see and hear you great, which I think everyone appreciates. You know, Justice Ginsburg drew some attention here, even after her passing, for sharing through her family, her thoughts about how to fill the vacancy. This is a time where there's, of course, a process ongoing with that. Do you think the justices do or should think about who will replace them and their retirement process while they are on the court? What are your views on that, as there's so much attention?
Well, I mean, if you say think about it, sure, people think about it. Of course, from time to time, you think about it. It's part of the aging process, and it's inevitable. Now, you have to, what you say, I mean, we stay out of politics. And really, sometimes it's very hard to just stay out. But the more the political fray is hot and intense and so forth, the more we stay out of it. And of course we have to stay out of it because the decisions we're making are decisions for 330 million Americans. And a lot of them won't affect all those people, but some of them affect quite a few. And so the people on both sides have to have the confidence that you, the judge, is a fair person. And so stay out of unnecessary controversy, and particularly political controversy.
I'll remind listeners and viewers here, Justice Breyer has been on the court here for 26 years, and legal scholar, as mentioned, long before that. So we couldn't possibly go through even a portion of your work or opinions.
You would be asleep.
But I'm going to read a little bit of one that I think lawyers and non-lawyers alike can learn from, and I'd love for you to just walk us through some of your thinking, because this is such a treat beyond the written word. In this 2019 case about the issue of when or how states can be sued, you wrote something that I think is an education in some of the larger themes of how decisions work. You wrote, quote, "Legal stability allows lawyers to give clients sound advice and ordinary citizens to plan their lives. Each time the court overrules a case, the court produces increased uncertainty." And you went on to write with your colleagues about supporting you about why in this dissent you didn't think the precedent should be overruled. You warned judges may be tempted to seize every opportunity to overrule cases they believe have been wrongly decided, but the law can retain the necessary stability only if this court resists that temptation, overruling prior precedent only when the circumstances demand it. And you went on to quote some of the progeny of Roe versus Wade, Planned Parenthood v. Casey, to explain your argument. What should we take from this dissent? What's important for people to understand about the law?
Well, that it has to stay pretty stable. Now, if you overrule a case, and I have joined opinions that didn't overrule a case, and if I'd been deciding the case initially, I might have decided it differently. But there we are. And the temptation comes from the fact that after a certain time, I say that because for 3 or 4 or 5 years, as David Souter said, or Justice Douglas, you go around that building and you're frightened to death. I mean, you may not reveal it, but you are. How do I know I really can do this? I mean, I thought I could, but can I? And after a while, you calm down and you say, well, maybe I won't do it perfectly, but I'll do it the best I can. And and that's just a uniform attitude that happens. But that comes with that is your realization your predecessors were just human beings, and they could make mistakes too. You find an opinion that you think is totally wrong, and you say, well, I mean, here I am. It was wrong. I think I'm right. Let's overrule it. Well, you do that very often, and you will see what happens. The lawyers will say, hey, let's try a few others. And before you know it, they'll be telling their clients, let's get this one overruled or that one or the other one. And pretty soon the clients will say, well, what is the law here? And others who haven't even gone to a lawyer will say, well, I'm not sure what I'm supposed to do. And there will be a mess. So don't overrule cases. But wait. What about Plessy v. Ferguson? What about Brown versus Board of Education? What about the cases that correctly said that law of segregation is no good? Were they right to overrule that? Of course they were right. It was bringing in a bit of justice. It was bringing in some justice into an area where there was no justice, and that's what the court is about. But that is unusual. Don't generalize from the fact you could do it once that they can do it all the time. Rare. And that's why you have to use the word rare. And is there a rule that will tell you? Sure, read through the cases, you'll find 50 rules. And the problem is they don't tell you. And ultimately, like many things, it's up to your own conscience. Just be sure it's very rare. And be sure of my goodness, when you realize what happened when they did overturn Plessy and Ferguson. It took 10 years, more, before that legal segregation was actually dismantled. And it wasn't the court that really did it. The court may have started it. It may have been a catalyst, but it took Martin Luther King. It took the Freedom Riders. It took 1,000 paratroopers sent from North Carolina to Little Rock, where they took those brave Black students by the hand and walked with them into that high school in Little Rock, where the governor was standing in the door effectively. It took a lot. Now, was it worth it? Of course it was worth it. Of course it was worth it. Because you were getting back to the very basic idea of America. But don't generalize from that case that you should start overturning things all the time. Rare is the key word.
Mm-hmm. Really appreciate the legal and American historical view. When this is something I just genuinely want to know, so I'm curious, and I think other people do too. So when we read a case like this, and we see you cite Planned Parenthood v. Casey, and people may take from that or want to take from that it's a warning about substance, about issues on abortion. Is that the right way to read that precedent, or could you have cited any number of cases regarding stare decisis?
Oh, you mean what was in my mind when I put that particular case? You know what's interesting? What's in the judge's mind doesn't really matter. What matters are the words on the paper. And it's important for the judge not to forget that, because it's those words on the paper that will be the guide to the future. Now, you have to admit that was a fairly interesting way of avoiding your question.
I admit it, and I'll mention for everyone, we've got some of the questions that participants have sent in, and some are probably things that a sitting justice or judge would not answer. But in the spirit of transparency, I'll read some of them, and some hopefully you can answer. You can pick among them for the reason.
Shut the curtain.
Oh, sure. Take your time. And I want to thank everyone. We've got several questions that people have submitted. One of them is about the process. Do you believe, especially with a vacancy right now, one person writes in, do you believe the confirmation process is appropriate and effective? Do you have ideas for changes? Another person asking, have you seen anything change or evolve in how the Supreme Court provides checks and balances? Do you have any thoughts on President Trump's released list of potential nominees now and for the future? And should Vice President Biden release a list? I'll mention for everyone's background, most candidates in both parties for president have not done that, but then candidate Trump did release a list in 2016, so that's an active discussion. And more broadly, because this is something I imagine you can speak to, you recently declined on behalf of the court to hear basically a question or an appeal about a state using a certain type of voting mechanism, ranked choice as opposed to a different type. And I think many people are curious what the actual way is that the Supreme Court and other courts do or do not even hear these kind of voting cases as we get closer to an election. So we call that maybe dealer's choice, Justice Breyer, if there's anything you want to say to any of the above.
Well, I'll say a couple of things. One, the confirmation process. It's important to keep this in mind. And I've said it probably 5,000 times, but 5,001 is okay. That is a political process insofar as nominating and confirming the judge is concerned. I wasn't the person who nominated me. It was the president. And I wasn't the person who confirmed me. I was the confirmed person. It was the Senate that did that. And so asking me about that process, I say, it's a joke, but sort of not too bad. I say it's like asking for the recipe for chicken a la king from the point of view of the chicken. Now, that's a way of saying I'm not going to get into that political thing, but I will say something about the political thing because I say this to the students and I say it to high school students or college students who are pretty cynical sometimes, and I don't want them to be. And that's why I love the Kennedy Institute. It's trying to get people to understand and to participate. But I'll say to them, look, I understand that I worked in the Senate. I worked for Senator Kennedy. I love that job. It's the best job I ever had, to tell you the truth. I loved it. And look, I learned there, watching confirmations and maybe beyond one, that senators by and large will ask the questions that they think their constituents want asked. They have a tie with those constituents, and if they go too far afield, they're not going to be senators very long, are they? Yeah. So you think there's too much hostility, and you think there's too much, they're wrong, we're right, they're wrong, etc. I'd say, yeah, maybe there is. And you know how to stop that? The senators are going to reflect what you want, so you better stop it. And the way you stop it is when you disagree with somebody, you talk to them about it. You talk to them about it. You try to convince them. You participate. You vote. And you do it yourself. And then maybe it'll be catching. And maybe others will do it too. But that's the system that this document, the Constitution, sets forth. That's why the First Amendment is there. So I mean it. Now, if I want to be tough to them, say a mean thing to them, I'll say, you know where to look to begin? I say, look in the mirror. Look in the mirror and start. Start and get involved and participate and practice cooperation and compromise. I mean, I could go on at length, but I think that's the key. The key is not going to be in Washington. The key is going to be in every town and city and state. When people come to the conclusion they don't want all this hostility, it won't be there. At least that's my view of it.
Very interesting. And with regard to when and how courts should or should not.
Yeah. Well, how does the court work? 5 minutes if you'd like. What do we actually do? Sure. First, begin by remembering this, that we deal with questions of federal law. That is, what is this word in the federal statute or in the Constitution? How does that apply? What does it mean? Those are the kinds of questions, and I emphasize federal, which means Congress or the Constitution. But most law in the United States is not federal. Almost all of it is made in cities, towns, states, and it's off bounds for us. That's up to state courts. But keep in mind the fact, and I say this deliberately to the students, you want to help your friends and neighbors, you go to the city council and you get involved in the school board or the art commission or something local and statewide, because that's the law that's going to affect them. Now, I'm not saying the Senate and the Congress are unimportant. They're important, but don't just jump to the conclusion because you read more about them in the newspaper that everything they do is more important than what goes on in the state. It's very often the contrary. We're only in our court considering the federal law. Almost 100%, okay? Now, how many cases are there? Cases involve people having arguments, and the first place they go is they try to get over it. Get over your dispute. And in 99% of the problem, they do. But sometimes they can't, then they go to a lawyer. The lawyer is supposed to help them get over it. Find a settlement, do something, bring them together. And maybe 80% of the time, they succeed. And then they get into court. But still, there are quite a few million cases in court, but most of them are state law. And most of them settle. Now, there are a few that don't settle, go to trial, get appealed, and have a federal question. How many? Maybe 80, 100,000 in a year are in the top appeals courts, and they involve federal questions, and about 8,000 of those come to us because they didn't like the fact they lost. I mean, remember, losing. The losing lawyer thinks the judge is an idiot. He doesn't say the judge is an idiot, but he says, oh, God, that's terrible. You know what the winning lawyer says about the judge? No, nothing. He says nothing. He thinks he's a good lawyer. Okay, that's why judging is okay. Got the point. Anyway, they come to us, the losing lawyers, 8,000, 7,000 a year, 150 a week, and they say, please hear our case. We don't have to. Please hear our case. And we each have law clerks, and the law clerks go at 150 a week. There are about 30 in the building, and they write these little memos. And so I will receive a stack like this on my desk each week, and I go through them pretty quickly, and I can go through them pretty quickly because of what I'm looking for, and this is the whole point. I am not looking for, oh, what fun it would be to decide this case. People think I do that. I don't. Well, what am I looking for? I am looking almost entirely to see if lower court judges have come to different conclusions on the same question of federal law. If they've all come to the same conclusion, why us? They're good judges. Hey, why us? Sometimes as an answer, maybe somebody held the law of Congress unconstitutional, but normally no answer. Okay. Suppose they've reached different conclusions. This is what President Howard Taft said this when he was Chief Justice. He says, if they've reached different conclusions on the same question, we better hear the case because federal law should be uniform. So you see, we could hear a case like, well, in the Internal Revenue Code at section there is a comma. And does that comma mean the next word, which was for, should be read as a which or a that? We heard that case. I liked it. Nobody else liked it, but nonetheless, we heard it. Why? Because there was a split, because different conclusions by different judges on the same question, or we could hear Guantanamo Bay. And so it isn't, I'm probably 99% of the time, I'm looking to see if there is a split. And other reasons possible. It could be an issue of such importance that we just have to hear it because the country needs an answer. But no, all right, now we hear the case, what happens? Shall I continue the process? They write briefs. Each side writes these little booklets. They're called briefs. They aren't brief, but they're called briefs. And so we get them and we read them. And then every 2 weeks or so, we have oral arguments where we ask questions. And then in a day or two, we meet around a conference table by ourselves and we go through the cases we just heard in order. The Chief Justice.
Justice, if I may, I'll ask a follow-up on the oral arguments, which get so much attention for various reasons. Can you think of a time where you or another justice had your mind change at oral argument when you'd already, of course, read the briefs and your clerks have done the research, and as you mentioned, it's gone through this process. Does that really happen, and does it need to happen?
Yes, because what you're doing divided two separate things. I come in thinking A wins and I go out thinking B wins. That happens, but not very often, 5%. But how I look at the case, what I think is important, that changes a lot more frequently. 30%, 15, 20%, and that matters because it's how the opinion is written. It's how the issues that are discussed, how they're approached, how they're analyzed, and how they're decided in words is often the key part of an opinion, not the result. Sometimes the result, yes, of course, but very often it's that. And that does change your mind. It does change it. It's a chance for us to ask questions. It's a chance for us to hear what our colleagues think. It's a chance for us when we go into the conference. You know, I've never heard a voice raised in anger at that conference, by the way. Never. People don't say rude things about each other, nor make jokes at each other's expense. It's professional. We go around the room, we discuss it briefly, write down what the others think in our book on each case, and then no one speaks twice until everyone has spoken once. Very good rule for a small group. And then there's some back and forth. But
where did that rule come from, Justice?
I don't know. It comes from ancient history, but there we are. Custom, it's the custom. And
I think another thing that you're uniquely situated to really educate us on, which again is at a level that's not about specific pending cases of which justices don't speak, is what are we in public and in the press getting wrong or oversimplifying as compared to your unique experience being on the court? We hear talk of not only whether people project their own ideologies onto the court, as I think you alluded to earlier, but we also hear talk of quote unquote votes, blocks, quote unquote swing vote, as well as anything that you might know of that I'm not listing that really, from the evidence and lived experience, we are getting a little off or wrong.
No, I think that's a huge problem. Huge. Because in fact, we're probably unanimous 40% of the time. The 5-4 cases are probably 15, 20%, not the same 5 and the same 4. I looked it up a couple of years ago and discovered, I think there were 18 5-4 cases out of all of them. A little high, but that's what there was. 12 of them were not what the press would call liberal conservative. It was more mixed up. 8 of them were. But I guarantee in each of those 12, it would have been written in the newspaper, in an unusual lineup. Hey, how could it be an unusual lineup when most of those 5-4 cases are unusual lineups? I mean, the problem is, and this is what, again, the students will ask me, they say, well, but aren't those the most important? I can't say yes, I can't say no. I can say they're the ones that the public has the most interest in. And so since the newspapers are out there to be sold, and since they want to appeal to their public, they will write about those cases as if those were the whole thing. And then they will say conservative and liberal. But my goodness, if that's what the job was, why in heaven's name would you want it? I mean, if you want to be a politician, go into politics. And judging is a different job. You are influenced by your background when you're interpreting these big words like liberty, freedom of speech. What is the freedom of speech? And you're influenced, but there's the text and there's the history and there are the purposes and there's the value and there are the traditions and the precedents and the consequences. All those things come in some way or other when you are deciding a case. And so it's important to remember it may be a political process that leads to the nomination of a judge. And a president may think, I've got someone who will always agree with me. That's what Teddy Roosevelt thought when he appointed Oliver Wendell Holmes, got him nominated. On the court in 3 months, Holmes had decided something Roosevelt couldn't stand. Roosevelt said, I could carve a judge with more backbone out of a banana. He was furious, but Holmes was doing his job.
Do you think every president comes to learn that?
Yeah, I do. And I think that what the presidents, when they may, there are big questions in law, in journalism, in any discipline. By the time you're 50 years old, you begin to have views of what I call in law jurisprudential views. What's law about? What is this Constitution about? What is this country about that this Constitution can work in this country? Those are big questions, and you can't often articulate an answer. But that doesn't mean that your sort of jurisprudential view isn't there. And if a president wants someone who holds views on those big questions somewhat like he does, he's probably luckier than Theodore Roosevelt, but he can be wrong there too. Because once that black robe goes on, you are a judge. And there is no point, and I haven't seen it, deciding things on political grounds.
Now, Justice Breyer, in law school, we are taught fairly firmly that this is a battle on the merits and ideas, and that's how it will be adjudicated. And there's plenty of evidence for that, as you just walked us through as well, all the many cases that are on the merits, by which I mean not some of the other things that the public may assume or imagine motivate the outcome. On the other hand, I always was wondering, well, there is the cost of litigation. There are the powers that be outside the courtroom. And it would seem certain issues, I'll give two examples, get more support, get more litigated, get more at bats, if you will, than others. I'm thinking of issues of high ideological support where there are motivated funding and constituency to keep pushing it. And I'm thinking of issues with business or corporate support, where individual companies and the Chamber of Commerce, I think as a measurable matter, can go to more courts and more at-bats and eventually, arguably, get more legitimate potential avenues for appeals and ultimately for the Supreme Court to hear their case. I'm curious your view, again, writ large, not commenting on any pending case. A, is that true or am I missing something? And B, to the extent you can say so, is that a potential inequity if other issues that might be as potentially valid jurisprudentially don't have that support to literally get through the system the same way?
Well, there are loads of inequities in our system. It's pretty tough for a person without any money or with only a little money and so forth to get into court at all.
Right.
There might be legal aid for him, but he might have too much money for that, but not enough to get in. I mean, in the criminal system, there is a system right now where the prosecutor, in effect, 90% of the cases, makes the sentencing decision. He recommends it, but there's an agreement. And the agreement in part is because the defendant, whom we certainly hope was guilty, because he's going to plead guilty, and if he doesn't plead guilty, he might get charged with a higher offense. I mean, these are filled with problems of equity, the law. It's far from a perfect system. The particular one that you mention, I have to say, I don't know. I mean, it may well be that what you say is something that lawyers say, who might like certain business, or clients say, or others say. But my job is to sit there, read those briefs, and the interest groups will file briefs. And what they don't really see is the name on the brief, please. I mean, it's what's said in the brief about the law that is going to have the effect. Now, it could matter in this way. We had a case about right to die. Really a tough case. Did you have a right to assisted suicide if you're very, very ill? Wow. We got about 80 briefs. And there were nurses associations on both sides. Doctors, healthcare workers, retarded people, hospices, all over the place. But what they were telling us that I wanted to see is, would a decision this way, how would it affect me? How would it affect the hospice? How would it affect those who are mentally ill? How would it affect this or that? Because I think that's relevant to the legal issue. You see? So, but that's what I'm trying to give you a picture of what the job looks like. You're there trying to decide the case. And what the lawyers have told the clients, and what the free speech, they can say what they want. And what the clients have told the lawyers, and what the newspapers say about what you're going to say, that's not so easy to get over, but get over it. They can say anything they want about this decision or that decision or something that I do. That's their right. And my job is to sit there and be the best, the best judge I can be. Law is not computer science. I mean, law is not where there's some kind of answer written on this great computer that you press the right buttons and get it. Law is an effort to allow, and I see that every day, to allow 330 million people in this country to live together harmoniously and productively. That's tough in many cases, knowing that that's a purpose. And looking at consequences sometimes looking at purposes, often, et cetera, et cetera. But that's the legal job. And the fact that I taught antitrust law for a long time might make me feel having a competitive competition in the market, having competitive markets is more important than some other thing. Okay, Breyer, we know you think that. Calm down. And just you try to do the job as best you can.
Yeah. Really, really fascinating. I'll mention for the justice's benefit and our viewers, we have about 5 minutes until I'll hand it to you for any closing or final thoughts. Another issue percolating through the nation, you mentioned the work that had to be done on civil rights cases, even beyond the ruling. And we've lived through this as a country, an original sin. In your position on the court, I'm just curious your thoughts on the movement and the term we've heard, Black Lives Matter. Because while it's partly about things that happen even before something gets to court, about police interaction and other systemic inequities, there's also a view, as you know, and everyone listening knows, an argument about whether the law also values Black and other lives equally.
It doesn't change it. And by the way, there is a constitution that says all people are entitled to equal protection of the law. And so laws that seem to me, and there also are statutes that say you cannot dismiss people or hire or hurt them in their work, and many other areas, the basis of race. So
I'm curious to ask you, when you see a movement like that right now, is your job more to be aware but not have it overly affect anything as you rule because you're inside the record? Or are you and other justices inherently and justifiably aware of what's going on out there that is not
of course you're aware of it, but be careful. Be careful not to substitute exactly what you'd like or what you think the exigencies of the moment call for what is basically a system of law. You see, at the same time, it's not computer science. So can you be unaffected? You try to be pretty unaffected by the fact of the demonstration itself or the fact of the article itself. Don't. That doesn't going to affect that's not going to affect you. But the importance of having equal protection of the law, which is in the law, you can say, yeah, I always thought that was important. And there, other people think it too. But the most important thing to me, the thing that I've seen on that court, which has impressed me the most, I see in front of me people of every race, every religion, every point of view. My mother used to say that. No point of view so crazy that there isn't somebody in this country who doesn't hold it. Okay.
Yeah.
And they're in the courts deciding their differences in court. And it's taken 200 years before people are willing to accept decisions that they really disagree with. I could name a few. And when I talk to students about this, I say, look, I heard Senator Reid say in respect to Bush v. Gore, the most remarkable thing is there were no riots. There were no paving stones thrown. There were no slingshots. There were no, pieces. They accepted it. And I say, I know what you're thinking. There are at least 30% of you in this audience, because it's a young audience, who think too bad there weren't a few riots. That decision was wrong. Hey, I thought it was wrong. I dissented. That decision affected us a lot. We disagree with it. Terrible. Too bad there weren't a few riots. I said, I understand. I understand what you're thinking. But before you come to that as a final conclusion, I would like you to turn on your television set and see what happens in countries who resolve their differences that way. Mm-hmm. So it's this document that somehow held 330 million people of very great differences of view and so forth together. And it says you resolve your differences if you can under law, not through force, and get into the courtroom or participate. You decide them in the Senate, you decide them in the House, you understand that. You decide them by participating in your community life. And that's preserved us, not perfectly. We had a civil war, we had slavery, God knows what's happened, but we've survived an awful lot. And I may be optimism, but I believe, those 330 million will continue to run a country under law, and there'll be a lot of ups and downs, a lot of them, but we'll get over that. Senator Kennedy used to say that. He said there are ups and downs. The country goes over here, then it goes over there. I mean, yeah, that's right. There are differences.
Yeah.
All right. Yeah, you see the point.
Well, we see it, but I think it's very edifying. I'd have you walk through all of this, and especially walk us through what we may misperceive, especially, I think, as we turn to the closing, reminding us really how narrow and at times parochial, I won't speak for anyone else, but I'll speak for those of us in the press sometimes, going towards the conflict or the narrower version when you've walked us through how it really works and everything that's perhaps out of the view sometimes. So I think we all really appreciate it. This is fascinating. It's rare to sit down with you, and especially at a busy time. And so I did want to give you the option before we bring in Caroline Burke. Is there any, because we talked about so much, anything in closing, Justice Breyer, that you wanted to say?
Yes, because we're at the Kennedy Institute, and I did work for Senator Kennedy, and I learned a lot from him, a lot. And I've told my law clerks this, they gave me a mug where they put this on it, words of Senator Kennedy. And the ones that I like to repeat to the students, and because I saw it so often. It was, listen, that's what you do when you go around the table. It's not, I have a better argument than you, ha, 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 because that just leads to, and I have a better argument than you, ha, ha, ha. Forget that. Listen to what the other person says. When you listen, you might think he's totally opposed, but my God, he says something. We can work with that. Let's work with that. And then maybe something will come out of it. And then he told us, which is right there, credit is a weapon. Don't try to get the credit. If the thing works, there'll be credit to go around. And if it doesn't work, who wants the credit? And I can't tell you how many times I saw him when something would work, and it would work with the help of those who disagreed with him, and the press conference would come along, and would he jump out in front? No. He'd push the other senator out in front. Orrin had such a good point here. He really helped bring this together. See? And you do that. That's called working with people. I learned that in the Senate. I learned that working for Senator Kennedy. And to tell you the truth, I learned a little bit of it in the 5th grade from Mrs. Squataquatsa, who used to have us write a project about San Francisco's history. And she'd have 4 or 5 of us in a group, and that group would get 1 grade for all 5 people, and they cooperated and they compromised because they were interested in working together. So I saw it. And I say that to the students because it's trite but true. That cooperation, compromise, participation, practice in all those things, and learning about the government. Well, that was Senator Kennedy. That's the Kennedy Institute, and I think that's worth passing on.
Really, really appreciate that. Some fitting thoughts from Senator Kennedy himself here at the Edward M. Kennedy Institute for the United States Senate. And again, I just want to thank everyone and Justice Breyer for being so generous with his time and his thoughts today. Thank you, Justice Breyer. And now I turn it over to Caroline Burke.
Thank you. On behalf of the Kennedy Institute, a most sincere thank you to both Justice Stephen Breyer and Ari Melber for sharing your unique perspectives on the vital role that the Supreme Court plays as the seat of perhaps our least publicly understood branch of government. As we head into what looks to be an unusual confirmation process for our next justice, it's critical that we all realize what is at stake and how our voices play a part to impact outcomes through democratic processes. We at the Kennedy Institute are proud to produce important discussions such as this one with Justice Breyer and Mr. Melber to ensure that as many people as possible are able to understand the intricacies of our democracy and engage in the civic life of our communities. Contributions from our generous members and supporters allow us to continue offering free programming and keep these critical conversations going. Please consider joining us and becoming a member today to make sure that we can continue to bring civic education and engagement to people across the country. You can find out more at emkinstitute.org/membership. And don't forget to check out justvote.org, as Mrs. Kennedy mentioned at the top of the program, to learn about your fundamental democratic right and make sure your voice is heard. So again, on behalf of us all at the Edward M. Kennedy Institute for the United States Senate, thank you and see you next time.